We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. When we state a land acknowledgement, we reflect upon and demonstrate recognition of Indigenous lands, treaties, and peoples. We think about what happened in the past, continues to happen in the present, and what changes we must make moving forward in order to further the reconciliation process and building a positive relationship with Indigenous peoples and communities. By making a land acknowledgement, we honor the land and Indigenous presence, which dates back to over 10,000 years. So we will get started. I'll let Sue take over, but again, for those that are just logging on, we're please asking you to turn off your video and mute yourself so we can see the presenter. Thank you.
Good afternoon and welcome to the HSJCC. The mandate of the Toronto Regional and Local HSJCCs is to engage in joint cross-sectoral planning, coordination, and integration of services for individuals with complex human services needs, which may include but are not limited to those living with mental health issues, substance use concerns, and/or behavioral dependence, or neurodevelopmental or neurocognitive disabilities, including developmental disabilities and dual diagnosis, who are involved or at significant risk of being involved with the criminal justice system. There are 4 local HSJCCs: West Toronto, North York, Downtown Toronto, and Scarborough. Each local HSJCC is responsible for working together to address local needs and reporting to the Toronto Regional HSJCC to help inform systems planning at a regional and provincial level. If any of you are interested in joining the local committee, please respond in the chat box with your email. The coordinator, Domenica, will contact you. Please mute yourself and turn off your video. If you have questions, use the chat box. We'll be doing a question and answer partway through and at the end of the presentation. We're also asking you to complete an evaluation. The link will be in the chat box. Your feedback will help us to plan future sessions and will assist us to continue improvement. It should take you 1 minute to complete, and it needs to be done before you leave the session. Today's presenter is Jonathan Rudin from Aboriginal Legal Services. Jonathan received his LL.B and LL.M from Osgoode Hall Law School in Toronto. In 1990, he was hired to establish Aboriginal Legal Services and has been with ALS ever since. Currently, he is the program director. Jonathan has appeared at all levels of court, including the Supreme Court of Canada. At ALS, he helped establish the Community Council, the first urban Aboriginal justice program in Canada, in 1992, and in 2001 helped establish the Gladue Aboriginal Persons Court at Old City Hall Courts in Toronto. Jonathan has written and spoken widely on issues of Indigenous justice. His book, Indigenous People and the Criminal Justice System, was released by M Publishing in 2018 and won the Walter Owen Book Prize for the Canadian Foundation for Legal Research in 2019. A second edition of the book was published in 2022. Jonathan teaches in the Masters of Law program at Osgoode Law School and was the constitutional litigator in residence at the David Asper Centre for Constitutional Rights and the University of Toronto Law School in the fall of 2021. Last but not least, certainly, he plays mandolin and sings in Gordon's Acoustic Living Room, a group that plays regularly in Toronto and has a number of videos on YouTube that I would encourage you to have a look at. So with that, I'm going to turn my video off and leave it to you, Jonathan.
Thanks very much, Miigwech Sue. Thanks for that introduction. And yes, welcome to all of you here. If some of you would look at our videos, it will make a huge impact because not a lot of people see the band videos. But anyway, I'm not here to talk about the band. I want to start by stating that the English name of the organization that I work for is Aboriginal Legal Services, but we have an Anishinaabe name, which was given to us by Elder Jackie LaValle. English names are easy to change. You just fill out a form and you file it with the corporation's branch and your name is changed. But when you ask an elder for a name, that involves a much greater commitment. The name we received is Gakina Gwai Wavama Debwewan, which translates as all those who seek the truth. It doesn't mean that we have the truth. It means that, as I interpret it, and everyone has to interpret these things in their own way, what it means is we help people try and find the truth as best they can. And sometimes those people are judges, and sometimes they're lawyers, and sometimes they're clients, and sometimes they're people in tribunals, and sometimes they're all of those people. And that's what we do. So today I'm going to talk about Gladue and Gladue Reports. And I'm going to try and cover 5 things in the 52 minutes that we have. I'm going to start by putting this in a broader perspective, a national perspective, by looking at some stats. And this is going to be really depressing, but you probably already knew that. After I look at that, I want to talk, and this is going to be one of the themes throughout this talk, about what do the stats say about Gladue and the effectiveness of Gladue in addressing overrepresentation of Indigenous people. Then I want to talk more specifically about Gladue Reports. What are they? What do they look like? What impact do they have on the courts? I think at that point, I'm going to try and take a break, and if there are questions that have occurred up to that point, please put them in the chat, as Sue mentioned, and she will ask some of them to me. And then I want to talk about the last 2 things I want to discuss are how Gladue reports are requested, and also Gladue in other contexts. And in this regard, you may have seen an article today in the Globe and Mail which talked about the expansion of the Gladue principles to trials, and this involved a case that I was involved in, and I'm happy to talk about. So let me start by talking about statistics. And the relevant time period is, we're going to start in 1996. So 1996 was the year that Canada significantly amended the criminal code. For the first time, judges were given guidance in the criminal code about how they should sentence offenders. And also in 1996, the criminal code was amended to enact section 718.2E of the criminal code, which said that judges should look for options to incarceration for all offenders, with particular attention to the circumstances of Indigenous offenders. And also at that time, other sentencing options like conditional sentences, which are non-jail options, were also introduced into the criminal code. And there's been some really interesting work done by Jane Sprott, Cheryl Webster, and Tony Dube, who are criminologists, who have looked at incarceration rates in Canada. And one of the ways you will know that we talk about incarceration rates is we talk about groups, particularly Indigenous people, but not exclusively, being overrepresented in the criminal justice system. And what we mean by overrepresented is Indigenous people make up 4 or 5% of the population, but 20% of the jails or 30% of the jails, they're obviously overrepresented. There are more Indigenous people in jail than one would expect. But Sprott, Webster, and Dube have taken another measure to look at incarceration rates that's very helpful in comparing rates of incarceration between different groups. And that's the rate of incarceration per 100,000. So what are the rates of incarceration per 100,000 of this group as compared to another group? And this allows for comparisons not just within Canada, but as we'll see internationally. So in 1996, when all the amendments to the criminal code came in, the imprisonment rate for non-Indigenous people in Canada was 98.6 per 100,000. So for non-Indigenous people, about 99 per 100,000 of those people would find themselves in jail. The Indigenous rate, in contrast, in 1996, was 510 per 100,000. So that means Indigenous Canadians were 5 times more likely to be in prison than non-Indigenous Canadians. And so the authors then moved ahead to 2017-18, the last time they were able to do this study. And in 2017-18, the non-Indigenous imprisonment rate dropped 20%, from 98.6 per 100,000 to 78.6 per 100,000. So one of the impacts of the legislation passed in 1996 clearly reduced rates of incarceration for non-Indigenous people. So there was a 20% decline. So did we see a 20% decline in incarceration rates for Indigenous people? And the answer is not only did we not see a decline, we actually saw the rates rise. So in 2017-18, the Indigenous imprisonment rate rose to 677 per 100,000. So that's a 33% increase. So while the non-Indigenous rate dropped 20%, the Indigenous rate went up 33%. And so now Indigenous Canadians are almost 9 times more likely to be imprisoned than non-Indigenous Canadians. And it's useful also to look at an international comparison, which the authors did in their article. The country that is the sort of poster child for mass incarceration in the industrialized world, as we all know, is the United States, our neighbors to the south. And we often feel very smug about our criminal justice system because we look at how jail crazy the Americans are and go, well, at least that doesn't happen in Canada. But if you look at the rate of imprisonment of Indigenous people per 100,000, which is 677 per 100,000, that is actually greater than the rate of imprisonment in the United States, which is 655 per 100,000, which means that from my perspective, I don't like to use the term overrepresentation of Indigenous people because that masks the nature of the problem. What we see in Canada is the mass imprisonment, the mass incarceration of Indigenous people. And the problem continues to get worse. Okay, so that's the real depressing news to start this. And it's important to have a reality check before we get into Gladue and all of its impacts. Now, one of the things that I know that people have said, and I know actually has come up at a previous HSJCC session, some people look at these numbers and say, okay, well, 1996 was when the criminal code was amended. 1999 was when the Gladue decision was enacted. We've had Gladue reports in Canada for over 20 years, and Indigenous rates continue to go up. So all of this stuff must be a failure. Gladue must be a failure. Gladue reports must be a failure. None of this can be working because if it was working, the rates would not be rising. And I want to state right up front that I do not agree with that approach. I do not agree that Gladue is a failure. And I know that from very personal experience. But we also need, again, to take a national perspective here when we look at statistics. So when we talk about Gladue, and we talk about Gladue reports, which I will talk about what they are in a minute, or a couple minutes. Gladue reports are not universally available across the country. One of the odd things, well, I don't know if it's odd, but one of the odd things about Canada is that while we have a criminal code that applies across the country, so we have one criminal code that applies everywhere, as opposed to the United States, where each state has its own criminal law, or Australia. We have one criminal code that applies across the country. But the administration of justice is a provincial responsibility, right? That's why most Crown attorneys are appointed by the province. It's why pre-sentence reports are done by provincial employees. The administration of justice is done provincially. And so what you see when you look across the country is that the availability of things like Gladue reports varies dramatically. So let me give you a quick snapshot. So if we move east to west and then go up to the north and then go from west to east and the north, I don't know why, I just like to do it that way. Gladue reports are available in Prince Edward Island, Nova Scotia, Quebec, Ontario, Alberta, British Columbia, and the Yukon, more or less. They are not available in Newfoundland, New Brunswick, Manitoba, Saskatchewan, except for a little pilot project in Regina, Saskatchewan, the Northwest Territories, and Nunavut. And as we know, Saskatchewan and Manitoba have significantly large Indigenous populations and a significant amount of Indigenous people in jail, and yet those are two provinces where Gladue reports are not available. And so that's one reason I think that Gladue has not had the impact that we might have seen, is because to implement changes to the criminal justice system requires commitment from provincial governments and funding, and that has not been universally available. The other thing that we've seen in Canada since 1996, is there has been a trend to make it more difficult for judges to rely on non-incarceral sentences. So I mentioned early on that conditional sentences, which are sentences that can be served in the community, jail sentences, but can be served in the community for people where the judge thinks an appropriate sentence is 2 years less a day or lower. Access to conditional sentences has been significantly restricted over the years. As well, starting in the early 2000s and then expanding from there, more and more mandatory minimum sentences were imposed, and those also prevent people from using non-jail options. And so that's another factor that I think has contributed to the mass incarceration of Indigenous people. Now, courts have been striking down restrictions on access to conditional sentences. They have struck down a number of mandatory minimum sentences. Parliament is considering Bill C5, which will restore access to conditional sentences for many offenses and get rid of a lot of mandatory minimums. And the federal government has expressly said this is to address the overrepresentation of Indigenous Canadians and also African Canadians. So we'll see if those things make a difference. But what I can tell you is that Gladue reports do make a difference. And I know this because at Aboriginal Legal Services, we have been writing Gladue reports since 2001. We're the first organization that created Gladue reports. We essentially made up the idea of Gladue reports. We thought, well, what are we going to do after the Gladue decision? Why don't we come up with an idea of a report? So we made up this idea of Gladue reports, and other organizations have taken them and they've adopted Gladue reports. It's not like we have a monopoly on it, but we have a significant staff preparing Gladue reports and what we call Gladue letters, which are provided when the Crown is looking for shorter sentences. And literally every day in Ontario, an Indigenous person is being sentenced with the benefit of a Gladue report or a Gladue letter prepared by Aboriginal Legal Services. And because we're not the only organization preparing these reports in Ontario, I can assure you that every day someone is being sentenced based on a Gladue report. And what we see when we prepare Gladue reports is that there is a real difference in the way people are sentenced. You are all familiar with the criminal justice system. Some of you will have been in sentencing court. And if you've been in a sentencing court, you'll know that it's often not pretty. I mean, judges have told me that they consider sentencings to be the sausage factory of the justice system. They often get done in minutes. You can have someone from start to finish be sentenced, the charge read, they plead and they're sentenced. It could take 10 minutes. And in fact, our system relies on the fact that we can process so many guilty pleas because the system relies on guilty pleas to survive. And when we do this sort of sausage factory sentencing, you'll often see Crowns being asked, what's your position on sentence? And that's the way it goes. The person pleads guilty. The Crown then says what their position is. And often the Crown knows nothing about the person they're sentencing. All the information they have about the person is 2 pieces of paper. The synopsis for the offense, which is not necessarily what happened. It is the sort of the most negative possible approach to what might have happened. They have the synopsis and they have the person's prior criminal record. And from that, they make up a position. And that is not a particularly informed position because they don't, frankly, have a lot of information. What the idea of Gladue Reports is they're there to disrupt that process, to say, let's stop. And maybe you should know something about the person you're sentencing, because if you know something about that person, maybe you won't make the assumptions that you're making, because if you only, excuse me, have 2 pieces of paper, you have to make up what you think this person's life is like. And if you don't know anything about it, you'll just fill in the gaps as you can. But Gladue Reports tell the story of a person's life. So our Gladue Reports are a narrative. They tell a story. And in that way, they're very consistent with Indigenous concepts. A lot of ways of learning, of teaching in Indigenous cultures, many cultures, is through stories. And so we tell the story of the person's life. And, you know, we know that people's stories are complicated. And it's not always possible to tell the truth, the absolute truth about someone's life, because we don't know. If you talk to different people, you will get different perspectives on someone's life. So when we write a Gladue Report, we talk to as many people as we can. And as much as possible, we quote those people. So the judge and the Crown and the Defense Counsel isn't just hearing what our writer thinks they heard from someone, but rather they're hearing those individuals' words. And we're telling the story of the person's life from a variety of perspectives. And those perspectives don't always match. People don't always agree. They don't always say, okay, yeah, that's exactly what happened. But often they're fairly consistent. But it's important to hear from a variety of people because, you know, if you ask someone, for example, what was your childhood like? We don't have the chance for a couple hundred people for you to put in your chat what your childhood was like. But for many people, our understanding of what our childhood was like is in relation to the world around us. So what was your childhood like? My childhood was okay. But what does it mean for someone to say my childhood was okay? How do you interpret that? Well, you can't interpret that really because the words don't mean anything. So what you do is you sort of put your idea of what an okay childhood is. And that then substitutes for what the person said. And of course, the difficulty is that the realities of most people, and certainly most Indigenous people before the courts, are so different than the decision makers in the courts, lawyers and judges, that without more information, people don't really understand what people's life was really like. So when we do a Gladue Report, we'll do more than just the person says my life was okay. We'll do more than just ask about that. We'll speak to the, excuse me, we'll speak to the person's mother, father, sister, and we will get different perspectives. But often those perspectives will present a greater picture about someone's life. And we'll also talk about the person's experience. Maybe someone in the family went to residential school, and we know a lot more about residential school today. Tomorrow is a National Day for Truth and Reconciliation. And that was sort of arose out of the report of the Truth and Reconciliation Commission. But when we start writing Gladue Reports in 2001, people didn't know about residential schools. They didn't know much about residential schools. They didn't know about intergenerational trauma. There was all sorts of information that people didn't know. And so in our Gladue Reports, in addition to talking to people, we also provide information to the courts about some of the systemic issues that have impacted Indigenous people that the court may not be aware of. So that includes residential school, addictions, the 60s scoop, the massive adoption of Indigenous kids, HIV in Indigenous communities, which has a different trajectory than HIV in other communities. There are all sorts of Indigenous specific issues that we can't expect judges and lawyers to know. But it's important for them to understand those things so that they understand the person's life. And the reason that we're doing all this is so that at the end of the report, we can make suggestions to the court about what an appropriate sentence might be. If all you know is that someone's committed an offense and they have 15 prior offenses, and the last time they were in court for a similar offense was a year ago, and they got a year imprisonment, then the Crown's position is going to be, okay, well, let's go for a year and a half, because that's all you've got. But once you start to know about the person, you hear about the person, when the person themselves starts to engage in thinking about their life and how they got to where they were, and start to think about what might change their life, then there are all sorts of different sentencing options that are available. And so we have seen, as I said, we have seen Gladue Reports make massive differences in people's lives. Just a couple of months ago, we did a Gladue Report for a woman in the Sarnia region who stabbed her sister's sort of ex-boyfriend in a fact situation very much like the Gladue case, and I don't have time to get into the Gladue case. Anyway, she stabbed him. She had no criminal record. She pled guilty to manslaughter. And we wrote an extensive Gladue report. The writer did a great job, wrote an extensive Gladue report for the person, talked about her life, her circumstances, the fact that she was looking after a child who had physical disabilities. And at the end of the day, she received a conditional sentence. She did not have to go to jail. That's a remarkable achievement that could not possibly have occurred without a Gladue report. Now, I notice that we're halfway in, and so what I'd like to do is pause here to take some questions and then finish that up and go on to the other two issues that I want to talk about. So, Sue, I'll turn it back to you. Do we have any questions from our studio audience? If not, I can keep going. But
we have a couple of questions.
Okay.
And this one, the first one goes back to the beginning of your presentation. Is it fair to compare the US versus a place like Australia?
So Indigenous incarceration rates in Australia are very comparable to Canada. I have had the privilege of been invited to Australia on a number of occasions. And one of the reasons that I've been invited to Australia is because the Canadian and Australian experiences are so similar. And one of the interesting things that's happened, and I'm speaking about this in October virtually at a conference in Australia, is that Australia is trying to think about how they can adopt Gladue reports for Indigenous people in Australia, because they see that as a real problem, that judges in Australia also do not have the information they need to sentence Indigenous people properly, and the overrepresentation rates in Australia are huge. And of course, the reasons for this is that because Australia and Canada were both subject to British settler colonialism. And the British, when they go to a country that they like and want to stay, and there are people who are already there, Indigenous people, their tactics are very similar. So what happens in Australia and what happens in Canada are almost identical. Thanks for the question.
Thank you. The next question is, do Gladue writers need certification to write reports?
So that's a very interesting question, and that speaks to sort of the different ways in which Gladue reports are provided across the country. So for Aboriginal Legal Services, and again, we initiated Gladue Reports, we do not require certification for our writers. Our writers are all Indigenous. They come from a wide variety of backgrounds. Some of them have master's degrees. We've had PhDs. We've had people who don't have a high school degree. But what they have is they have a skill and an ability to interview Indigenous people and to summarize that information in a report. But also importantly, we supervise those writers and we review all the reports. And so the reports that go out are the product of the writer, but they come out under Aboriginal Legal Services letterhead, and we are responsible for it. And so the courts have not required any certification. It's also important to note that Gladue reports are not expert reports. So sometimes Crown or defense will ask for an expert report, but we are not, our Gladue reports are not expert reports. Our writers are not reaching conclusions about the person. We're not reaching conclusions about their life. We're not saying this is what happened to them. We're not saying, if we have a diagnosis from a doctor, we're saying this is what the doctor said. But if we don't have a diagnosis, we're not making assumptions. This does actually distinguish Gladue reports at the moment from IRCA reports, individual race and cultural assessment reports, which are done for African Canadians, which are often done by way of expert reports. And there are reasons for that, which I don't have time to get into.
Okay, during the sentencing of an individual, is it general practice for all crowns to be presented only information from 2 documents about the individual for outcome for their possible sentence?
So if do not have a Gladue report if they're Indigenous, don't have a pre-sentence report if they're non-Indigenous, there's very little. The sentencing, as I said, happens in 10 minutes. And so what the Crown usually has access to in most sentencings, again, particularly if it's a guilty plea, if someone, for example, is charged with a criminal offense, has a bail hearing, is denied bail, they often will then immediately move to plead guilty because they don't want to spend a lot of time in pretrial custody. You go right away to a sentencing. The Crown will have very little information. They literally will have, on the one hand, the synopsis of the offense, and on the other hand, the prior criminal record. And they will be asked to come up with a sentencing position. There's a really interesting book by a guy named Daniel Kahneman called Thinking Slow and Fast, or Thinking Fast and Slow, I can't remember. Anyway, he's a Nobel Prize winning economist, and he talks about a phenomenon called what you see is all there is. And what he's saying in that is that in many circumstances, we don't make decisions based on the best information. We make it on the information that we have available to us. So in sentencings, that's often all the Crown has. And frankly, many Indigenous people, the lawyers who represent them, know very little about them. There have been many studies that talk about the fact that defense counsel often spend very little time with Indigenous accused people. And so when it comes time for defense counsel to make submissions, they often have very little to say. They just sort of they may have met the client once, they've asked them a couple questions, and that's what they tell the judge. So yes, sentencings can be really ugly looking things.
I think the next question might have been cut off, but read what's here. What are your thoughts on Gladue principles reports, which seem to be often used in place of Gladue reports, where timing is an issue?
Okay, so I'm not sure what a Gladue principle report is. At Aboriginal Legal Services, we produce 2 types of documents. We produce Gladue reports, which are often 20, 30, 40 or more page documents about an individual. And those take, 6 to 8 weeks to prepare, sort of the same length of time that a pre-sentence report takes to prepare. Now, if, for example, the Crown is only looking at a 90-day sentence, and if the person's in custody, for example, you don't want the person to wait longer than they would spend in custody for a report. So we do now have things called Gladue letters, which, when we know that the Crown is interested in a 90-day or less sentence, we can produce in 3 or 4 weeks. And those focus not so much on the whole history of the person and their life, but also more directly focuses on what sentencing options are available. Because frankly, and I have just recently said this to a bunch of judges at a conference, a 90-day sentence represents a failure in imagination on the part of defense and Crown. 90-day sentences are stupid and they are largely pointless, but they are harmful because people who get 90-day sentences lose their housing, women can, and men, but mostly women, can lose their children. There are lots of detrimental impacts of a 90-day sentence, but no one's getting anything out of a 90-day sentence. So if we can write a Gladue letter and say to the court, look, here's a better idea than 30 days, then the courts are often willing to do that. So I don't know what a Gladue principle letter is, but that's what a Gladue letter is.
Do ALS Gladue writers know the registry process to be a verified card-bearing Métis citizen with the Métis Nation of Ontario? I have seen where a Gladue writer cannot find enough background to write a complete Gladue report, but the defendant is then subsequently issued a letter from MNO registry confirming the individual is in fact an MNO citizen and soon thereafter gets their card. It seems that Gladue writers are often approaching the reporting form a First Nations perspective. So status, non-status, Métis, Inuit.
Okay, so thank you. That's a really important question. One of the issues about writing Gladue reports is we write them for all Indigenous people, and it is largely a self-identification process. For lots of reasons, it is very difficult. Not all Indigenous people know huge amounts about their background. Now, in some cases, someone will have a status card, which will point us in a particular direction because we will know then something about their parents and other relatives. There are people who do not have status. There are other people who are Métis. And when we write a report or other groups write a report, we try and find the information we can about the person's background. So the first place we go is to the individual. So where the individual can tell us about their Indigenous background, that's really all we need to know. But on some occasions, a person will say, I don't really know anything about my Indigenous background. I just was told that we're Indigenous. Or someone might say, and this has happened, I have a card. And we say, how did you get the card? And they go, I don't know. And we are in a strange time, and this will all work itself out, but we are in a strange time in Canada where we have a government-imposed system, which is status cards, which is very problematic. But we also have many organizations, some, completely legit organizations, and some organizations that have sprung up, and they issue cards to people and say, you are Indigenous. And the person who gets that card doesn't always know what that means. And so sometimes when we write a report, the issue isn't do you have a card or do you not have a card? It's what do we know about your background? That's what we have to write in the Gladue report. So give another example, and I'm sorry but the DNA tests are very popular. So sometimes people go, I had a DNA test done and I'm 11% Indigenous. I'd like a Gladue report. And the challenge for us is, leaving aside how valid and let's assume for the moment that the test is valid. The question, though, is, well, we have to talk about your Indigenous background. That's the point of the Gladue report. What about your Indigenous background? So tell me about that 11%. And if the answer is, I have no idea where that comes from, then it's very difficult for us to write a Gladue report. Now, if we're not able to write a Gladue report or a Gladue letter for someone, we do always say to the court that we are not saying the person is not Indigenous. The person may well be Indigenous. And we're not saying there are not Gladue factors. There may well be Gladue factors. And we're encouraging counsel to raise that. So we're not making decisions about whether someone is or is not Indigenous. But in order to write the report, we need to know something about the person's background and history beyond the fact that they have a document of some sort. It's a incredibly important issue, and I have and can talk about this for a long time, but I will have to hold back for now.
Well, we do have lots of great questions. So the next one is systemic issues faced by Indigenous people start far earlier than criminal justice systems, but may create pathways toward criminal justice system involvement later in life. Are there applications for Gladue principles in areas such as child welfare and education systems? Earlier application of principles may amplify success in reducing incarceration later. And any thoughts on that?
That's a great question, and I'm going to do what I hate to do, but I'm going to say that I'm going to answer this question later because I'm going to take one more question, and then there are a couple more things I want to talk about, and I will include answering that question there. So I'll take one more, then I'll deal with a couple more things, and then we'll go back to the questions.
Perfect. Okay, so what is the essential difference between a Gladue report and a pre-sentence report? Okay,
great question. They've all been great questions. I hate to say great question because then people, well, my question wasn't great. No, your question was great too. So first of all, I have to do this. Publisher says, here's my book. I've shown it up. Anyway, there's a discussion about this in the book, which you can get out of the Toronto Public Library. You don't have to buy it. It's ridiculously expensive. So there are a couple differences between a pre-sentence report and a Gladue report. And a couple profs from U of T, Kelly Hannah-Moffat and Paula Marudo, have written extensively about this. And one of the big differences is that pre-sentence reports, for the most part, are written from a risk assessment perspective, that probation officers are given a risk assessment tool that they apply when they speak to someone, when they're doing a PSR, and that informs their report. Now, in some provinces, in Manitoba, they expressly advert to the risk assessment form. In Ontario, they don't always do that. But the idea is, here are risk factors, and they identify those risk factors and discuss them. A Gladue report, rather than being focused on risk assessment, focuses on risk explanation. Why did this happen to someone? So, for example, one of the risk assessment factors is being from a broken home. One of the risk assessment factors is having a parent who was in jail. Just one of the questions, last question we got. There are all sorts of systemic factors that mean Indigenous people are greatly at risk for offending. And one of the interesting things about risk assessment tools is that they have two components. There's a dynamic component, which you can change, and there's the static component, which is the world you're born into. And Indigenous people are often very high risk, not because of anything they've done, but because of the life that has their family has endured. And so the point of a Gladue report is to explain risk as opposed to work on a risk assessment basis. So the documents are very different. There are a couple other differences. One is that for the most part, PSRs generally don't quote people directly, and we do. But I'm going to leave it at that. So I want to move to two more things, and then we'll go back to the questions for the last 5 or 7 minutes. We could just do questions the whole time, and that would be great too. But I just want to talk about two other points. One is Gladue reports are not ordered by the court. They are requested by the court. And I make that distinction because it's an important one. Judges can order a pre-sentence report because pre-sentence reports are contemplated by the criminal code. And if a judge orders a pre-sentence report, the provincial or territorial government has to provide one. But Gladue reports are not provided for in the criminal code. They are not discussed in the Gladue decision. There's something that we came up with and have been adopted more widely across the country. And a judge can't order us, for example, to do something because the judge doesn't have the power to tell us to do anything. They can ask, and we will generally follow up on that. But so they have to be requested. And we have a form on our website, aboriginallegal.ca. If you go to Gladue Reports, you can see the form. And Gladue Reports can be requested by the judge. They can be requested by the Crown. They can be requested by Defense Counsel. They can't be requested by anyone other than those three, although I guess if you're self-represented, you can request a report too. So the requests get, ideally, the online form is used. They're sent to our office. Our Gladue report and Gladue letter coordinators send them off to the managers who assign them to a writer. So that's how they get done. Also, these reports and letters can only be done after a plea has been entered or the person has been found guilty. So we can't write these things before the matter is resolved, because one of the issues that we talk about in the report is the circumstances of the offense. And obviously we don't want to talk about that, nor can we, if the person hasn't been found guilty or pled guilty. So I want to talk the last remaining 7 or 8 minutes before I go back to questions. I want to talk about Gladue in other contexts. So the question that was asked that I said I would answer later, and I'm going to, where else can Gladue be used? So one of the significant things about the Gladue decision, which came out in 1999, the Ipili decision, which came out in 2012, the recent decision by the Ontario Court of Appeal in King, which came out earlier this week, one of the things that's recognized by the court is that Indigenous people face systemic discrimination, not just historically, but still. So, and that systemic discrimination is felt not only outside of the justice system, but in the justice system as well. And it manifests itself in many different ways. And so as a result of this, there has been a recognition, particularly over the last 5, 6, or 7 years, that the Gladue principles, the sort of the broad notion of understanding the realities of Indigenous people and having that inform decisions by people in the justice system, that has a role not just in the sentencing process, but has a role in other places as well. And so courts have said that Gladue considerations apply when someone applies for parole. Gladue considerations apply in extradition cases when the Minister of Justice is asked whether they will send someone, an Indigenous Canadian in this case, to another country to face prosecution for a criminal offense. It applies in cases of civil contempt. If Indigenous people are protesting occupation of property, of land that they say belongs to them, and a landowner gets an injunction preventing that protest, that's a civil injunction, they want to enforce that by jailing the person, Gladue applies there. Gladue applies to the way Indigenous witnesses are treated in court. This recent decision in King, which just came out, is about something called Corbett applications, which Corbett applications occur when an accused person testifies at trial. Normally, their prior criminal record can't be the subject of discussion by the Crown, but if you testify at trial, the Crown can raise your prior criminal record to argue that your credibility is in doubt because of your prior criminal offenses. They can't say you did it because of these prior criminal offenses, but you can say your credibility is in doubt. Well, one of the realities that we know is that Indigenous people plead guilty to criminal offenses more than non-Indigenous people, and often not because they're in fact guilty, but because of systemic factors that push people to plead guilty. These are called wrongful conviction guilty pleas. And the reality of wrongful conviction guilty pleas has been recognized by Crown attorneys across the country and courts. And so if we know that Indigenous people plead guilty to things they didn't do, then to present that to someone who's trying to testify on their own behalf at a trial as though that speaks to their credibility doesn't make any sense, because in fact, it may well not speak to credibility for that person. They may not have pled guilty to failing to attend court or not observing their probation, not because they're actually guilty, but because they felt they had no choice. So the Gladue principles have expanded to many different areas within the criminal justice system, including now the trial process. Now, the question that was asked specifically was about child welfare. And we have spent a lot of time talking about Gladue and the Gladue principles in child welfare. And to be honest, this is an area that we are still struggling with. And the reason we're struggling with it is because when we produce a Gladue report, it's after a finding of guilt. And it's about that particular individual. So person X pleads guilty, they get a Gladue report, and the judge says, okay, I'm now going to sentence you person X, and I've got the benefit of this Gladue report. But in child welfare, it's more complicated because the person before the court is not the parent, it's the child. And we're not doing, in some ways, we're not doing a Gladue report about the child. I mean, we may touch on that, but the issue for the court is, what is the parent's ability to look after the child? And so we could write a report, and we've talked about this, about putting the lives of the parent in a context that the judge will understand. What makes it complicated in child welfare, and I'm sorry to go into this amount of detail, but it's the only way I can get to answer the question properly. In the child welfare context, these reports, if they're created, are often done before the judge has decided whether the child is in fact in need of protection. And some lawyers are concerned that if the judge hears about all the awful things and the challenges faced by the parent, that the judge could say, you know, I'm really sorry about all these awful things that happened to you. And clearly they're not your fault, they're systemic. But nevertheless, these things happen to you and they may not make you, through no fault of your own, a good parent. And so some lawyers are reluctant to have these reports written because the determination about whether the child is in need of protection or not has not been made. So we are still struggling, and this is being done across the country. Are people trying to struggle with how do you apply Gladue in the child welfare context? Because clearly that's important, but it is also clearly challenging because the issue is not how do we deal with the person who has, in many ways, had a lot of these issues impact them, but the subject is the child who, and so that's what makes it a lot more complicated. I wish I had an answer. I can tell you that I am on a committee that meets regularly to try and sort these things out, but we have not sorted it out yet. So Sue, we have 5 minutes left. So why don't I turn it back to you for some questions? Yeah, let's do that.
Okay, so there was the question about the difference between Gladue reports and pre-sentence reports. Following that, there was some conversation about when probation is asked to do a PSR, but to include the Gladue principles, but often when there is no time for a Gladue report. So could you talk a bit about why we have cutoff times, you know, the 90 days, that sort of thing?
Sure. So there are times when, I mean, in most cases, if a pre-sentence report can be prepared, we can probably prepare a Gladue report because it takes roughly the same amount of time to do both of them. If there's a desire to have a report done very quickly, sometimes we will do a Gladue letter, even though the person's looking at it more than 90 days in order to get a report in. The other variable in this is that we don't have people across the province. So for example, in Northern Ontario, we don't do Gladue reports in Northern Ontario. In Northern Ontario, they're done by Anishinaabe Nation, Grand Council Treaty 3, and some friendship centers. And in some of those jurisdictions, it can take a lot longer to get a Gladue report done. So I know that there are places in Ontario and there are places in the country where it can take 4, 5, or 6 months to get a report done. And certainly in those cases, people may not want to wait that length of time. But for most of the places that we provide services for, we are usually able to get a report done in the same length of time that it will take to get a PSR. But again, we are not in every jurisdiction in the province. And you know, sometimes we'll just be busier than other times.
Another question is asking for a reference on King. I think I have that and I can forward it to Dominica to distribute.
Yeah, that'd be great. It will be on the Ontario Court of Appeal website, but yes, you have the decision.
Also, can a Gladue report be given if an individual identifies as Indigenous but does not hold a status of Indian card?
Yes, certainly. Yes, certainly. And the other important thing to point out, and you don't have to be connected to the community to get a Gladue report. So we often get Gladue report requests from people who were adopted when they were very young, and they don't know much about their Indigenous background. And all we sometimes know about their Indigenous background is a notation in the Children's Aid file that one parent was Indigenous. So we will write a Gladue report for that person because one of the circumstances of Indigenous people is overrepresentation in child welfare. And they will often, and there's a lot of information about adoption breakdowns in with Indigenous kids in interracial adoptions that are different from other interracial adoptions. So we'll certainly write a report on that. So you don't have to have those sorts of things. You don't have to have a status card. You don't have to have a connection to the community. Disconnection is often relevant. But obviously, if someone is so disconnected that they don't know anything about why they think they're Indigenous and we can't find anything, and trust me, we look, then we may not be able to write a report or a letter.
Okay.
And I think I probably have time for one more.
I have one more question that's going to be very easy for you to answer.
Okay.
If the Gladue report is aimed at the explanation of risk, which may draw sympathy from the court, how does the court deal with the actual risk presented? Does the Gladue report deal with mitigation of the risk?
Yes. I mean, obviously, the point of the report is not just to, the person is the person, they've committed this offense. So when you know about the person's history, the recommendations in the report are usually expressly designed to address those things that led to the person's offending in the first place. So the answer is yes. And with that,
we have come to the end of the presentation. Thank you, Miigwech Jonathan, for presenting to us today. And we ask that everyone fills out the, I don't know which side it's on, survey, please, before you leave.
Okay, thank you all very much. I've got to go to another presentation.
Thank you, Jonathan.
Okay, bye-bye.